Hello and welcome to Legally Speaking with me, Tarun Nangia. Today, we are going to speak on a very important subject. This is a judgment by Justice Abhay Oak and Justice Pankaj Mithal. It speaks about that the police cannot be allowed to tutor prosecution witnesses, and the court has asked the DGP of Tamil Nadu to take action against the errant officers. This is, in a sense, being reiterated by the Supreme Court is important because the number of prosecutions in India have gone up significantly in the past few years, and these kind of issues send down a message that the Supreme Court is conscious of, sometimes things that may happen that shouldn't happen. And what message is the Supreme Court trying to send down? We are going to discuss that today. We are on the law point, not on that specific case, but on the law point of police cannot be allowed to tutor prosecution witnesses and the impact. May I welcome Justice Talwant Singh, a very, very well-known name in the field of criminal law. Good to see you, sir. I have with me Senior Advocate Pramod Dubey, a well-known criminal advocate, practices at the Delhi High Court and the Supreme Court of India and other forums. Good to see you, Mr. Dubey, and looking forward to some interesting insights and analysis from you. I have with me Archit Singh. He is a partner at law firm Circle of Counsels, argues at the courts in Delhi, the High Court and the Supreme Court and other forums, handles a lot of cases in criminal law. Good to see you, Archit, and looking forward to some insights from a cross-section of cases that you are handling currently. At the outset, I'll go across to Senior Advocate Pramod Dubey. In about the next 4 to 5 minutes, could you just explain to us the importance of this message that has been sent by the Supreme Court and some practical examples of what can happen if the police get away with tutoring prosecution witnesses?
Thank you, Tarun. At the outset, I would like to mention the examination of the witnesses are very crucial aspect in the criminal jurisprudence. Because you have filed the charge sheet, you have framed the charges, then the matter is kept for the recording of the prosecution witnesses. So what happens if you go for the tutoring the witnesses? You are basically going to cause the prejudice to the accused person. So many times we have come across in our experience appearing before the courts that they have not recorded the statement of the witnesses. Because the fundamentals, once the statement is recorded and duly signed by the maker of the statement, that statement would be inadmissible piece of evidence that would be hit under section 162, because the process for recording the statement is under 161 CRPC. So they don't record. They prepare the statement of the witnesses. Then they call the witnesses in the police station, all in the court premises. They tutored the witness. They compel the witness to you state this fact before the court of law. And then the prosecution, the defense is given the opportunity to cross-examination. So you are bringing all together the new facts to support your statement by the witness, who is basically a stranger to the event, a stranger to the fact. You are tutoring the witnesses, and then witnesses are going to depose before the court of law. You have just mentioned that Justice Oak has recently passed the order, Justice Oak and Justice Mithal. But before that, I would like to mention in 2023, also Justice Oak has passed the order with Justice Bindal in Pradeep versus State of Haryana, where the same view was taken. The judgment was authored by Justice Oak, and the same views was taken by Justice Oak, that once the witnesses are tutored by the police, their testimony would be not taken into the credential, that would not be considered, and the testimony would be rejected. In so many cases, like these days, you'll find in the rape cases or in the POSCO cases, there is a prevailing practice, the tutoring of the child witnesses. So you are tutoring the child witnesses. The court is very liberal, appreciating their statement. So you are tutoring the witnesses. Child witnesses are making the statement. The POSCO is a very serious offense. Presumption is against the accused person. And it is very difficult to come out from that presumption. Once there is a statement, there are all the things. Here, I would like to make the distinction within two facts. One is, as per section 159 Evidence Act, Indian Evidence 6, refreshing the memory of the witnesses. Suppose you have to depose before the court, you have forgotten the fact, you want to refresh the memory. The law provides, yes, you can go through your statement, refresh your memory before the making the testimony. And Mr. Singh, Justice Singh is here. He has the vast experience recording the statement while he was the special judge and district judge. So many posts he has held during his tenure. So that time you can, even during the recording of a statement, you can refresh your memory. There is no problem. But the tutoring altogether, I have got the experience, and we have seen in these days, especially in the CBI cases and the white collar crime, there is a PARB officers or the holding IO of the matters. They will call the witness. The matter will come at sharp 10 o'clock. The presiding officer will ask, yes, witness is here. Yes, sir, here. Call the witness. Sir, he will coming. He will take 5-10 minutes. So you are taking the witness in the separate room and you are tutoring the witness, showing everything. You have to state this fact, that fact. If the witness is not supporting what you are saying, sir, witness is not willing to depose today, adjourn the matter for some other day. Because you want the statement as per your desire to ensure the conviction immaterial, whether the accused is innocent or accused is guilty, accused has committed the offense or not. And the very classic case, let us take the corporate cases. So there is a management, there is an allegation, you are prosecuting the higher officials of the management. What you are doing, you are making the employees, some of the employees of that corporate sector as a witnesses. They are completely unaware. You have recorded the statement. You are calling the employees. You are putting the pressure, you have to state this fact the way we are suggesting to you. And you are tutoring the witnesses. And you are causing the prejudice to the accused. And you are putting the pressure and the threat to the witness. If you are not going, then we'll prosecute you because there is a statement. Though he's not owning the statement outside the court, but you are tutoring and the witnesses are deposing before the court of law. This is the one aspect. The second aspect also in the blue collar crime, where there is no document. Statements are, evidences are not the documentary evidence. The entire thing based on the oral testimony of the witnesses. In the oral testimony of the witnesses, tutoring the witnesses is more dangerous. In the other side, if the evidence are the documentary nature, so still you have to compare the testimony with the document. But in the oral testimony, where the eyewitnesses, you are creating the eyewitnesses, though eyewitnesses are not there. Like in this case, recently Manikandanam, Justice Oak has authored the judgment, he said, they were the interested witnesses. All the 5 witnesses were the interested witness. You call the witnesses at the police station the previous night. You tutored them, and this fact has come during the course of the cross-examination. So I think this practice should stop, and there should be check and balance on the police official. They should not indulge in this kind of the practice just to prove your case, because the proving case you are being rewarded, but the innocent person is facing the conviction. The judges are returning the finding of the guilt because judges have to appreciate only the statement which are before the court of law. And they are not the witnesses. Whatever is coming, the judges will analyze. And you are fabricating the statement. So tutoring the witnesses is very dangerous practice. It should be stopped. It should not be encouraged. And I would rather say the court should impose the penalty or take the strict action against the person who are indulged in this tutoring of the witnesses.
Thank you, Senior Advocate Pramod Dubey, for explaining this in detail. I will go across to Advocate Archit Singh, partner from Circle of Counsels. Archit, you are known to handle a lot of such cases which may involve these kind of issues that may crop up. In about the next 3-4 minutes, share your analysis of the same and also comments on what the judges have said and why it is important for the Supreme Court to reiterate this.
So, Tarun, if I may start by saying, criminal justice system in India follows a practice which is known as a non-adversarial form of practice. And there's a reason behind it. We are a non-adversarial form of criminal justice system because what is the job of a law enforcement agency? It is not to find conviction. It is to conduct a fair investigation and find out truth. And once the truth or whatever version of it comes to them, to present these facts as they are found by them before a court, so that the court can then take a decision on the basis of the facts as presented by the agency. That is, I'm talking to stage of charge, whether we should even proceed with the case or not. Now, why do the agencies actually get into this practice of resorting to tutoring? Is actually to try and justify their investigation or to overcome certain loopholes that they find in investigation. So a lot of times what I have observed is that agencies feel there are certain gaps in their investigation or a certain witness during the cross-examination because they've already tutored. Now you can tutor a person very easily for what to say in an examination. But cross-examination is the tough domain because criminal lawyers who know how to really cross-examine can find out ways to really crack the examination. So this is where they try to seed in ideas that, this is how you go about it. How do you do? Like my guru always used to say, I don't need 10 witnesses to prove a case. I need one honest witness who can stand the test of trial. But you see, what happens is when you tutor witnesses, you destroy the entire integrity of an administration of the criminal justice system as a whole. And as this judgment has shown, tutoring happened by a prosecution agency, right? But the reason court has even set aside the conviction in this case is because once your evidence becomes unreliable, and that is the sole reason of the conviction, then it casts a shadow and doubt on the entire procedure in the manner the investigation is conducted and thereafter. Because if you're tutoring a witness at the stage of evidence, then that means there is certainly something more that has happened during investigation, a stage where there is no or limited court interference. This is one of the problems that we are facing today, especially in white collar crimes, where agencies have a lot of power and they have a tendency to abuse this power by calling in people. As Pramod sir rightly said, that a lot of times what happens is people are called into the rooms and asked to sign certain statements or state it in certain way. So there is a lot of fear. There's a fear of backlash. You must understand that the agency is an agency of the state. There is a lot of power and there's a lot of apprehension that people have that how will this agency behave? And where does this come from? It comes from tendencies of agencies to do certain things. This fear needs to go away. And the only way the fear will go away is in the manner how this court, Justice Oak, has decided to take action against the erring officers. Because unless the courts, which are supposed to supervise in a way and take care of the criminal administrative system, they don't. Now, look at this case. This fact was proven in 2008. The statement of the witness had come. Trial court saw it. High court saw it. There is a travesty of justice that no one in this entire point had pointed out, that there was a tutoring of witnesses. And this affects my right to a fair trial, a fundamental right of a citizen. So I think when a question of reliability of a witness comes into place because of tutoring, it can have many repercussions and it honestly destroys the entire case. There are times we've seen you may have a fantastic case, the prosecution, but because of tendencies to tutor witness, they actually destroy their own case. So I think courts need to step into this, and it is a very welcome step or by the observations made in the judgment by Justice Oak.
Thank you. Thank you for sharing these analysis with us on this important point that Justice Abhay Oak and Justice Pankaj Mithal have reiterated. I'll go to Justice Talwant Singh, and needless to say, he has spent a long time as a High Court judge, is now a senior advocate at the Supreme Court of India and other High Courts also. Most recently also now in Punjab, Haryana a lot, if I'm not wrong. I want to know from him since you have an experience on both the sides, can you analyze this aspect in detail for us and also give your insights on the comments made by Senior Advocate Pramod Dubey and Advocate Archit Singh?
Yeah, Tarun, basically, I think most of the investigation which is taking place, this is confined to the investigating officer himself. The witnesses, generally, they do not know what is the statement which has been recorded, which is attributed to them. Because Section 161 talks about the statement which is to be recorded by the investigating officer in his own words. Okay, it is not to be signed because it will be hit by Section 162. So sometimes when the state he is confronted with his 161 statement at the time of his evidence in the court, the witness is taken by surprise. He said, no, the IO has never asked this question to me. I do not know from where this statement has been attributed to me. So this is, a classic case where these 5 interested witnesses, as I presume, I think they were the relatives of the victim, they were called to the police station a day in advance. They were told how they have to depose, what is their 161 statement, and they deposed accordingly, which resulted in conviction of the accused persons. Another important point which the court has observed, that there were independent witnesses to the occurrence which were held back by the police. Because the prosecution agency always has the liberty to not examine a person, even if he has been cited as a witness. If they say that, look, I have cited 10 witnesses, I want to examine only 5. The accused side can't force, or the court can't force them to examine all the 10 witnesses. So what they did, they examined, they tutored and then examined only the interested witnesses who got some stake in the matter. And on the other side, to prevent the court from reaching to a reasoned conclusion, they held back the witnesses who were alleged to be the eyewitnesses or the independent witnesses, you can say. I think this is a practice which should stop. But on the practical side, as Mr. Pramod Dubey has said, it is happening in every court complex. Now I can say, as an advocate, it happens. You'll find investigating officers maybe on the same day outside the court. Reading those 161 statements to the witnesses. And sometimes it happens, they put the court in a very awkward situation. The accused side will come inside the court and they'll inform the court. Sir, the IO is tutoring the witness outside the court. So at least they go to that extent. Okay. So I think it's a warning sign to all the police officials. First, during investigation, they should record the true version which is attributed to a witness. If a witness is not present, you make him present at the spot. Okay. If the witness has something else to say, you in your statement recorded as 161 CPC, attribute something else to him, which he may not be even knowing. And as my younger colleague has pointed out to you, at the time of cross-examination, this witness cannot stand his ground because the IO can, put the words in his mouth as well as the statement of Section 161 CRPC is concerned. But he can't anticipate which type of questions will be asked by the learned advocate who is going to appear for the accused. So under these circumstances, I think, as rightly pointed out by my co-panelist, the purpose of investigation is not to punish the alleged accused by hook or crook. The purpose is to do a fair investigation. And if the accused can't be punished, he can't be punished. Okay, there is no, you can say, compulsion to file a charge sheet against an accused. It can be a closure report also. It's not necessary that every case you will find the witnesses. If the witnesses are not there, there are many instances where witnesses are planted. Okay, persons who are not present at the spot, they were shown present at the spot, and then the statements which suits the investigation in a particular line, those statements are recorded. So this is, I think, a very welcome step. And since in the last para, the DGP has been directed to investigate the matter and see to it that the culprits are punished. people, police officials who took that, liberty of going beyond what is their brief.
Thank you for explaining this in a free and a frank way that you always do. We really appreciate that. I'll go to Senior Advocate Pramod Dubey at this point. Taking on from what Justice Talwant Singh shared with us all, I want to ask you, what is the risk of wrongful prosecution? Because, say, the police may believe that somebody is guilty, then tutor witnesses accordingly, and then he may be framed. The charge sheet may be filed. Is there a large risk of wrongful prosecution?
Of course, the person is innocent. You don't have any evidence against the person to prosecute. Now you are creating the witness, writing the statement that rightly mentioned by Justice Talwant Singh. You are writing the statement in your language, own language. Now you are calling the witnesses either in the court or the chamber of the prosecutor or the police station, and you are tutoring the witness. You have to state this fact. Not only that, you are also putting the witnesses under the fear of the perjury. If you are not going to support this statement in the court of law, then you will be prosecuted. Or if you resign, then there is a prosecution against you. You have make the false statement before the court. So you are putting a lot of pressure on the witnesses just to prove your case. This is not the duty of the prosecuting agency, because the prosecuting agency is basically the state. A state has to protect the right of every individual. Accused persons are also the citizen and of this country, and they also have the right to be protected by the state. Here you cannot go in only one dimension to prove your case by false implication, creating the witnesses, creating all the things. Because, this is basically the personal liberty of individuals. You have put the person on the malicious prosecution. And if you have more than one witnesses, the criminal jurisprudence says if there is a consistency in the witness statement of the witnesses, then the facts proved, because there tends to be plus, 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 not the plus, minus, minus. So plus, plus, plus. So there is a corroboration of the evidence. So this fact has been proved, and this fact is itself sufficient to find the guilt. So you will be punished. So in all this scenario, if you see, and see in this, what is the beauty? In this judgment of the money condemnum, credit goes to the defense counsel who brought this fact during the cross-examination that they were tutored. Suppose the defense is not able to establish the factum of that the witnesses got the tutored by the agency, what would be the fate of the case? And in this case, Archit has rightly pointed, it was overlooked by the trial court judge, it was overlooked by the high court judge, ultimately the Supreme Court. Had the Supreme Court ignored this fact, then the innocent person would have been convicted, and you cannot compensate the personal liberty of an individual. Though we have the procedure for the compensation, for the malicious prosecution, but I don't think you have come across. We have not come across, yes, the person has filed the suit or the case for the malicious prosecution, because the day you will file, you will be implicated in some other case. So everyone is interested, oh, I've been acquitted, matter over, you start your new life. So no one is going to follow this procedure. And a state agency must be fair, because you are assisting the court to bring the truth before the court of law. The moment you are tutoring the witnesses, indulging in the malicious prosecution, you are directly hitting the judicial system.
Thank you so much for explaining this in detail. I'll go to Advocate Archit Singh, partner at Circle of Counsels. Archit, I'm largely putting the same question to you. A, risk of wrongful prosecution. B, risk of the whole case falling apart, like you highlighted in the last answer, that if it reaches the Supreme Court and the defense counsel is able to establish that the conviction was secured on account of tutoring the witness. And C, do you think the court, which is Justice Abhay Ok and Justice Pankaj Mithal, have sent a strong message that the Supreme Court will not tolerate such an act of tutoring witnesses?
Thank you, Tarun. Tarun, coming to address your first two questions at the outset. See, there's a natural risk when tutoring happens regarding wrongful prosecution. Now, when a person, just to put it out broadly, what is wrongful prosecution? See, I would like to distinguish between two things: malicious and wrongful. Malicious means there is an interest to do something. Sometimes wrongful prosecutions happen because of a contrary interest. You see, what happens is, if I'm a police officer or any law enforcement officer, I've set up a case. Especially if you go to blue collar or white collar crimes, right? When I say blue collar, I mean heinous crimes. You're also curtailing a person's personal liberty at that point of time. Because in these offenses, there is a high chance that at the outset or some point in the case, you're getting arrested. Now, I'm a police officer or a law enforcement officer. I have to justify my actions, including the action that I've kept someone behind bars for so long, including the fact that I'm going to have to convict this person. So it leads to an entire chain cycle wherein the officer's interest stops aligning with his job description. So naturally, there is a high risk of tutoring in such a system. And see, tutoring doesn't happen in presence of people. In this case, as Pramod sir rightly pointed out, it was found out. The defense credit goes to the defense counsel. But what if it was not found out? And in 99% of the cases, it is never found out. What happens behind the show stays behind the show. So that is why the importance of trial courts and is very important. I would say Supreme Court is a very important court in this country, but trial courts are the most important because evidence is created in the trial courts. So good defense counsels can actually make a difference over here, can actually make a change in the lives of people. But risk, as you rightly pointed out, is there. And as far as the case falling apart, as Pramod sir and Talwant Singh sir rightly said, when you're confronted by a defense counsel, you often fall because you've been told what to say, but you've not been told how to answer back when certain googlies come your way. So this certainly there's a risk. And as far as your last question goes, I appreciate the Supreme Court sending a message. It is a strong message when you send to call the DGP of a state and ask them to take inquiry into the matter. But is it sufficient? Maybe not, because what will this lead to? A departmental inquiry? A suspension? But what about the years that have gone? So I think we need more. There is a further requirement. I think the Supreme Court has done the best it could. But perhaps if the individuals start taking the state to court and start seeking compensation, start exercising their rights, which, as sir rightly pointed out, that at times we're scared. Oh, the case is done and dusted. Thankfully, now I'm free. Why bother? Start your life afresh. As sir rightly pointed out, that is the tendency of people. But how can you make a change is to actually enact some laws, actually make more safeguards. And these safeguards are tough to put in place.
Point well taken. Thank you for explaining this aspect, Archit. I'll go to Justice Talwant Singh. The Supreme Court has sent a message via this judgment. Your final words on the importance of the Supreme Court doing so.
Yeah, basically, I think this practice has to stop. This is the first message. No tutoring. You come to the court with true facts. These may be in favor of the accused. These may be in favor of the complainant. I think the because as the investigating agency is a state, so state can't favor the complainant or state can't favor the accused. The true fact should come before the court because court was not present. The learned judge was not present at the spot. IU had visited the spot. The witnesses ought to have been there if they are deposing that they were there. And in whatever scene they create or recreate in court and in their evidence and cross-examination, the learned judge has to decide the case on the basis of the said evidence and the exhibits which come before him. I am reminded of a judgment again of the Supreme Court of 1994, State of Punjab versus Moriram and others. And this decided by Justice K. Jayachandra Reddy and Justice L.K. Singh, where it was observed that this report, in our opinion, appears to have been brought into existence with the help of a person well versed in these matters. They are talking about the FIR being registered. After noting the injuries of the deceased person, even injuries were described in detail by the complainant, who was now on some other roof. He was not there present. He said there was a lantern, hung on a post in the wall, and the incident took place in the courtyard. I was able to see which injuries were caused. When the interested witness falls in line verbatim and repeats the same in a parrot-like manner, naturally that creates some amount of suspicion about his veracity. If PW4's evidence becomes suspicious, then the evidence of PW does not inspire. So this is the observation made that if you are repeating sentence by sentence, the same complaint which you got recorded or your evidence in 161 after passage of number of years, okay, then it means that it is not your truthful evidence. This is what you are tutored about and you are repeating the same. I've seen cases where witnesses forget the color of the shirt. They even forget about, which injury was caused by whom. But in this particular case, State of Punjab versus Moriram, the person attributed each and every blow to the accused person separately, as if they were attacking the victim one by one. Others were waiting. One was inflicting the such and such blow. Then other person inflicted such and such. They were waiting for the witness to record everything. Repeat it when the complaint is taken to the police station and FIR is registered and in the court. So this is what should stop. The witnesses should come to court with clean hands and everybody takes an oath. I think we take the oaths very lightly, okay, and take an oath of Gita or any form in which the court administers to you, and then then we don't speak the truth. I think this should stop. It's a message not only to the police officials, but even to the witnesses and to the court also.
We thank the Supreme Court for doing so. Thank you so much, Justice Talwant Singh, for sharing the anecdote, the case also with us. And more so, when we do our next shows, we are going to also record very soon on the admissibility of evidence in a statement that has been made in the police station, especially in the light of the new laws that India is soon going to enforce.
One thing very important, Tarun, I would like to mention here. There is a provision for giving the false evidence that would be applicable to the witnesses. But in the new law, there is no provision to countering the tutoring.
It's there.
Thank you so much for that. This requires a separate.
Will do everything.
This is a separate 1 hour show or maybe 2 hours, because this is so. I will not allow you to now share more information. This is for a fresh show, but I appreciate that you shared it. Thank you so much, Justice Talwant Singh, Senior Advocate Pramod Kumar Dubey, and Advocate Archit Singh, Partner, Circle of Counsels. You all provided invaluable inputs on this accord, and looking forward to seeing and recording with you soon on the 3 new laws, a hint of which Senior Advocate Dubey just shared with us. Appreciate your joining us. Thank you so much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.